from talking about, in general terms, access to a tort, to talking about access to a court and what a court will and won't look at and how, in the very specific context of the refugee crisis. And I am going to start this session. You're going to get used to this by now, or at least by the end of this course, you'll be used to it. I'm going to start this session as I did yesterday and as I did last week, by asking you to make some contributions which will enable us all to get going on the topic. I've just made you all people who are displaced for various reasons from where you live. You have excellent reasons for getting out of where you live, and you're going to want to apply for refugee status. You're going to want to apply somewhere, and somewhere for present purposes is going to be within the European Union. What is going to affect where you decide that you would like to apply for refugee status? I know that 10 o'clock in the morning is a bad time to have to think.
Sorry, gender semantic?
Yes, can I intervene?
Yes.
Please, go ahead.
Thank you very much for the question. So if I were in that very terrible situation, I would probably look at some country where I know the culture and also probably know the language in order to be able to integrate in some way in that new culture. Or otherwise somewhere where I have somebody whom I know, whether these are friends or even family. So I would look for something familiar. So in order for that terrible situation to mitigate the terrible situation, I would try to find something that is familiar to me, either through the culture or through some friends or family. Thank you.
Thank you.
There is also Iman Elotmani. Would you like to intervene?
Yes, hello, do you hear me?
Yes, please.
I'd say that I'll choose a country where my values and that matches my state of mind, where I am in terms of thinking. If I, let's say I get out of my country because I am someone with politics, involved in politics, and then I'll choose a country where that actually matches my values, or a country where, as someone said before me, I know someone, I know the language eventually, or eventually a country where I know that the refugee application system is favorable, if I may say. Thank you.
There is also Tanya Chibangu.
Yes, thank you. Good morning. If I am in this situation, I may be attracted to a country that calls itself le pays des droits de l'homme. So that means that my rights may be more respected if such a country has like an international reputation of respecting people's rights as a human.
Okay, thank you. Any more contributions, please? This is very useful.
I don't see any other hands. Don't hesitate to... yes, Juliette Kasmaker?
Yes, can you hear me?
Yes.
So I would look at the system itself. So apart from the culture, I would look at whether the asylum conditions are favorable for my case. So whether if I apply for asylum, then I would be most likely to be accepted as a refugee or not. And then other things in the system as well, like the healthcare system, the judicial system, in addition to the general asylum conditions.
Okay, now that is all extremely helpful. Thank you, all four of you, for those contributions. what you have done and said, and you are, by the way, it's an entirely good reaction and a natural reactions that you have given me. And you have very comprehensively given me the reasons why member states are worried about letting applicants for asylum go where they want to go. Let me explain that statement, because I'm not criticizing what you said, by the way. What you have said is entirely sensible from the perspective of the individual asylum seeker. You know, of course, I'd prefer to go somewhere where I can actually manage to integrate, where I know the culture or the language, where there's family, where there's already a community of people from where I come from, somewhere that respects my values, somewhere that's going to be efficient and helpful in treating my application for asylum, that will look after me while I'm applying. I mean, of course, right? That's all totally natural. And the reaction of member states, even as it were nice member states, who are on the whole friendly towards applicants for international protection, when they hear all of that, is to say, oh, we are going to have thousands and thousands of applications if we're nice to people. Right? Because, you know, you've just beautifully described why, if, for example, Sweden is nice to applicants for international protection, everyone's going to try to get to Sweden. I mean, this is, you know, this is not rocket science. It's very understandable, and it's also like a straight line. This is why the member states are uncomfortable about having a situation in which applicants for international protection can choose freely where they go. The next thing that I need to put in place is an understanding, a very brief understanding, of what is called the Common European Asylum System. Because the idea is that by now, within the European Union, we have actually managed to get to a situation where there are some agreed general rules as to how you treat applicants for asylum. And in theory, I say again, in theory, it shouldn't matter where you go and apply, because irrespective of where you apply, right, you should find that actually there is a common system that applies to you. So, I mean, there is, in terms of the substance, the substantive rules, there is a common set of procedures under Directive 2013-32. There's a common set of procedures. There is also a common set of rules under a directive where I think it's 33 from memory. It's a very similar date. There is a common set of rules for the conditions for looking after people while they are waiting for asylum, their asylum application to be determined. There is a common set of rules that should be applied actually to the substantive question of whether you get asylum or not. In theory, please note those words, in theory, all of these rules have been harmonized at an EU level in order to respect the obligations of all the member states under the 1951 Geneva Convention on asylum, on refugees, right? So in theory, it should not matter where you go in order to have your asylum application considered. Now, I'm now going to go back over to you, and I'm going to say, have you looked recently at a map of Europe? Remember that if you're going to be looking for asylum, you're going to be coming from somewhere, and also that you may not have all that much money, and how you get to Europe may be an issue. So again, over to you. Thinking about that map of Europe, where are you going to arrive? Are you going to arrive equally in all member states, or are there some member states where it's more likely that you're going to arrive?
So, yes, Iman El-Othmani.
Yes, I think that we're most likely to arrive in countries such as Greece, Spain, Italy, the borders of the Europe, if I may say so. And that's actually the issue. The issue is that a lot of people arrive through Spain, Greece, Italy, for example, and we see such things as camp of people and nowhere to go.
Absolutely, I agree with you. Are people likely to arrive on the west coast of Ireland?
There was Loxa Alesini. I don't know if you want to. Oh, Loxa Alesini.
Hey, I don't remember raising my hands, but in any case, I wanted to point out that obviously, I mean, the system was placed wrong from the beginning with pressure on external borders. But then I also wanted to say that when Dublin was set in place, the borders were not the same as they are now. So where you can arrive and seek asylum protection has kind of changed as the years passed by in the EU.
With the respect, the
broadened.
geography of Europe hasn't changed since the Ice Age.
Yes, but I mean, the European Union geography has changed in the past 20 years.
Wait a minute. If we are looking at the Dublin 3 regulation, all right? If we're looking at Dublin 3, we're looking at a regulation that dates from 2011. Okay? By 2011, we have got everyone except Croatia that we now have, right? But with the exception of Croatia, we have everyone else that's there. And they were already there in Dublin 3. Now, you are entirely right if you're going to say to me, but Croatia wasn't there, and the refugee crisis was in 2015. I'm going to agree with you, all right? If that's your point, I agree with you entirely. But the basic underlying issue, there wasn't Croatia, but there were still other external borders. If Croatia, imagine Croatia is still a third country, people could still come up the Balkans route and they're going to arrive at that corner of the European Union, right? Conversely, to take my example that I gave a moment ago, they are very unlikely to arrive in Galway on the west coast of Ireland, because in order to arrive in Galway, you need somehow to have come across the Atlantic. And that is really unlikely, For the same reason, if you look at the shape of the Mediterranean, there are places where the crossing is easier and there are islands. You mentioned, of course, Greece, Italy, absolutely. You might think also of Malta, in fact, because Malta is not that far away as a staging point. You might also think right at the other end of the Mediterranean, you might think about what classical mythology used to call the Pillars of Hercules, about the Straits of Gibraltar, because that is another place where the two land masses are close together. Conversely, in the middle of the Mediterranean, they're not so close together. So it's fairly unlikely that people are going to try to arrive, next door to Nice, because it's a long crossing. And people are not going to arrive on the outside Atlantic coast, on the Portuguese coast. They're not going to arrive in the Bay of Biscay. I mean, this is the basic issue about geography. And the Dublin system, thank you for anticipating the next point that I was going to make. The Dublin system is, sorry, Emmanuel, please.
Yeah, just because there were two other people wanting to intervene.
I'm sorry, go ahead. Yeah.
Our colleague Stain Smith.
Please go ahead. Sorry.
Thank you. No, it's fascinating. I hope you hear me well.
Yes, we do.
Okay,
Yes.
thank you. I've heard the usual countries that are mentioned in this
But we
debate.
don't hear you now.
Oh, so I've heard mention of the. Am I not audible?
Is it okay for you, Eleanor?
Yeah, go on talking.
Okay.
I'll go on talking, and I'll do that if I can hear you, and that if I can't hear you. All right.
Okay, that's excellent. That's excellent. As soon as I'm done, I'm going to grab my headset because I'm not using that at the moment. Apologies for that. So I've heard the usual countries, Greece, Spain, Italy mentioned. I'm often struck by the fact that we don't immediately think of countries like Poland, where quite a few people from Chechnya might enter, and a few interesting cases of the European Court of Human Rights have been litigated recently, but also a large percentage of people fleeing from the Ukraine were not necessarily treated the same as others. And I'm bringing up Poland, obviously, because this is a lecture series on the rule of law as well. So I think it's interesting to also talk about that particular country. Hungary as well, of course, but Poland receives more people. So yeah, but thank you.
Thank you very much for that. I hadn't actually finished going around the map, but yes, absolutely. Please go ahead.
And
yes.
There was still Genja Semantic who wanted to intervene too. So you have the floor, Genja.
Thank you very much. So I just wanted to add, since I'm coming from Serbia, which is not a member state of the EU and was pretty much focal point of the migrant route Western Balkans. So what I wanted to add is that there is also a question whether the refugees or migrants will get into the EU, and if they don't get into the EU, where will they stay? And also, even if they get into the EU and travel through the member state, let's say from Croatia to Slovenia or from Croatia to Austria, for me, it was interesting to see how the Dublin criteria are interpreted, because we also have the issue of which state will be responsible for their asylum application. And somehow it is like pretty clear when we read the Dublin Convention, the Dublin regulation, sorry. But then it is interesting how the states behave and how did they let persons cross their borders in order, because they didn't want them to be, let's say, their problem. And it was very interesting to me to read several cases which dealt with this issue before the Court of Justice, in which I believe you interpreted some of the Dublin criteria. What does it mean to give a visa, or what does it mean to illegally cross one state or another? So I just wanted to point out that even if we have rules, like pretty clear rules there from 90s, which are just like replicated, some new developments. Some new developments lead us to try to interpret them in the newly established situations, which might change our understanding of these, let's say, positive rules, which we don't think they're changed, but there might be changed through the development in the courts and in the migrant crisis. Thank you.
Mm-hmm. I'm very interested by your statement that we have clear rules. Because I think that the court, and certainly this Advocate General, really struggled with the rules in, for example, AS and Jafari and Mengelsteb, just to name 3 cases. I mean, the rules are all, look, there's a more general point to be made here. When you legislate, you try to envisage what the situations may be that you're having to cover, all right? And depending on your style of writing, you write law which is more or less dense. If you are writing according to a civilian style of writing, you write down big principles, and the text looks very clear. If you're writing according to the traditional drafting style of an English statute, it's almost impenetrable. They are horrible to try to read, even for somebody trained in that tradition like myself. You have a long definition section right at the end, usually about section 270, which tries to define every term in existence. And the actual drafting is very, very punctilious, very minute, very, we'll write everything down and cover all possible eventualities. For what it is worth, my experience under the English system and my experience under EU law, which is more the continental drafting style, my experience is exactly the same. Cases arise that fall through the holes in the law. That is my experience as a working lawyer. And it really doesn't matter too much which of the two systems you have. And the reason that cases arise that fall through the holes is that no one who writes a law has a crystal ball. Nobody has perfect foresight as to all the circumstances that may arise. Nobody foresaw the 2015 refugee crisis generating the sheer number of refugees that it did generate. It was the biggest population movement since World War II. Something approximately like 750,000 people coming up the Balkans route. Now, that is not, of course, and I'm very grateful to the person who drew attention to Poland and Hungary, that's not to say that people aren't coming from other places. Your basic problem about refugee law is that if you have a place which looks relatively safe, relatively stable, and relatively prosperous, think the European Union, right? And in other parts of the world, you have bad things going on, whether you're talking about the war in Syria, or you're talking about Chechnya, or you're talking about the Ukraine, or you're talking about Afghanistan, or I could go on, right? If you have bad things happening in other places and people can somehow manage to beg the money, borrow the money, be helped by their friends and family, get up and get out, right? Then you will get population movement and you will get people applying for asylum. I will also point out to you that the problem is actually bigger than that, because, and this is, you will find a reference to this, if you want one, in the footnote right at the end of my shadow opinion in AJ. You will find a reference to the fact that actually there is a real problem insofar as climate change happens, and climate change makes certain areas of the developing world increasingly untenable as places to live. If you get more desertification, you push communities which were on the margin as to whether they could stay there and live. They cease to be on the margin, they can't stay there. I speak with some force because as a child, I lived in Brazil. And in the northeast of Brazil, for 3 years in a row, there was no rain. And I remember standing at the northern edge of the city of Sao Paulo and watching truck after truck after truck arrive with people hanging on to the outsides. There was no point in their staying in the Nordeste. If they stayed in the Nordeste, they were simply going to die. So they came south. Some of them had a roll of bedding and some of them had nothing. And they were literally hanging on the outside of the trucks to get down from the Nordeste to Sao Paulo. And in due course, there were enormous shanty towns outside Sao Paulo with the refugees. So climate change is also going to create, if we don't do something about that, climate change is going to create an additional push factor on refugee movement. But to come back round, all right, not only the Western Sahara route, yes, there is also movement into Poland. The Dublin criteria do have a hierarchy. For those who've looked at the Dublin regulation, there is a hierarchy of criteria in there. and you are meant to look at the criteria which determine the state responsible. And there is a very elaborate set of arrangements for identifying via the Eurodac system if somebody's fingerprints have been taken, so you know that first they were in a different member state. Most of the applications to another state to take back somebody, the vast majority, are done on the basis of Article 13, on the basis that the person crossed the frontier into that state before they came to your state. All right? Now, all of this is fine in a sense. It's a machinery between member states for deciding who is responsible for processing applications. I'm now going to introduce the human being into the story. We're not talking about parcels. We're talking about people. All right? We are talking about individual applicants for asylum, and individual applicants who are meant to have a right to be treated as individuals with individual rights and with individual dignity, not as statistics. Now, that is a basic collision, right, between the position of the member states who have a lot of applicants they need to deal with, and it's a big administrative problem, and it demands resources. And if you integrate or try to integrate a lot of people who are from different cultures, you are worried about whether the society is really going to absorb them properly and so on. There's all of that. And then you have your individual applicant. And this is where the rule of law point comes up. If you are an individual applicant for asylum and you get a decision, a transfer decision from the authorities in the member state where you are, where you've applied for asylum, saying, we're not going to deal with your application. Member state X has agreed to take you because you traveled through member state X getting here. So we're going to ship you off to member state X. Can you challenge that decision? And that is the essence of what was under Part A of my notes for today. You have a case under the Dublin II regulation, which is the first one I put on my list, a case called Abdullahi, case 394 of 12. And that was about Dublin II. In that judgment, the Grand Chamber in 2013 produced a ruling which is not very friendly towards individual applicants. If I read the dispositif to you, the dispositif says, Article 19.2 of Regulation 2nd Dublin must be interpreted as meaning that in circumstances where a member state has agreed to take charge of an applicant for asylum on the basis of the criterion laid down in Article 10.1, named as the member state of the first entry of the applicant for asylum into the European Union, the only way in which the applicant for asylum can call into question the choice of that criterion is by pleading systemic deficiencies in the asylum procedure and in the conditions for the reception of applicants for asylum in that member state, which provides substantial grounds for believing that the applicant for asylum would face a real risk of being subjected to inhuman or degrading treatment within the meaning of Article 4 of the Charter. Now, that is a very, very tight, small door to get through. It essentially limits you to saying, you can't send me back to Greece, because at the moment in Greece, this was truly the case at a particular moment in time. At the moment in Greece, there are so many applicants for asylum that the Greek system simply can't deal with them. And the accommodation for asylum seekers and the processing of the applications, the whole system is in meltdown. You can't send me back to Greece because there are systemic deficiencies. But anything short of that, under Abdullahi, you couldn't challenge a transfer decision. So for example, if you had family in the member state where you were applying, and the official processing your application had simply overlooked the fact that you had family, you couldn't challenge that. All right, Abdullahi was a very, very restrictive decision. Then, however, we moved from the Dublin II regulation to the Dublin III regulation. And within the Dublin III regulation, there is then a new provision about access to the court for judicial review. Dublin III tells us that the applicant, or certain other people, shall have the right to an effective remedy in the form of an appeal in fact and in law against a transfer decision before a court or tribunal. And then there are various additional provisions under, I probably don't have time to read you all of Article 28, so please go and look at it yourself. You'll gather that I am trying to look at two screens simultaneously here, because I've got the text of the Dublin III regulation up on a different screen from the one that I am using to talk to you on. So bear with me 1 second while I just go down to Article 27 and see whether you get notification of the transfer decision under Article 26, and then Article 27 has the first paragraph that I've read to you, that you have the right to an effective remedy in the form of an appeal or a review in fact and in law against a transfer decision before a court or tribunal. You have to be given a reasonable time for doing that. And then you also, it is for the member states to choose how exactly that appeal interacts with the fact that there's a transfer decision, so in principle you should be sent off to another member state. Does the fact that you've made an appeal give you the automatic right to remain in the member state? Is the transfer suspended, or do you have the opportunity to request the suspension? You know exactly what the arrangements are is a matter for the member state, but you're meant to have this effective remedy. And in Geiselbach, which is case C6315, and again in Karim, we had the question, all right, what actually does this mean? Does this mean that you have a right, but it's not a big right? In other words, do we just pick up Abdullahi and say, yeah, all right, nothing very much has changed, we apply Abdullahi? Or do we say, second possibility, the text of Article 27 is not the same as the text of the Dublin II regulation. So if you can argue that a very clear fundamental right of yours has been violated, can you go to the court? Or, third possibility, do you think that it should be interpreted more widely than that? So that, in fact, if the Dublin III regulation is being misapplied to your case, then you can go to a court. So this is really a rule of law issue. It is about how much right do you give the asylum seeker to go to the court and say the state is applying the rules wrong. And these aren't the substantive rules, you understand, as to whether the person gets asylum. That's at a later stage down the process. These are the rules about which member state is examining the application for asylum. And I'm going to say, perhaps not as modestly as I should, if you want an example of an advocate general trying to help the court by laying out what the three options are and discussing them and then saying why that advocate general supports a particular reasoning, please actually have a look at my opinion in Geiselbach, because that is exactly what it was. Clearly a moment when the court had to decide whether the situation had moved on with Dublin 3 or whether it hadn't. That's why the case was in front of the Grand Chamber. In the opinion, I set out the three routes and I said you should be generous on access to a court. I will share with you the fact that I did not think the court would necessarily follow me. I thought there was a reasonable chance that the court would not just apply Abdullahi, because after all, the wording of Dublin 3 is not the same as the wording of Dublin 2. I thought there was therefore a fairly good chance that the court would be more generous in terms of access rights, but perhaps it would opt for the middle road, so that it would only give access to the court if your challenge involved saying that actually there is a problem, fundamental rights problem here, so you must look at it. And the court was more generous than I had feared it would be, and it actually went for the broader ruling. And when it went for the broader ruling, that was absolutely great. But when you go for the broader ruling, of course, you hit the fact that the Dublin 3 regulation is a very complicated regulation. And in being a complicated regulation, this is why I reacted a little with the colleague who said there was a set of clear rules, because I have never found, I mean, you know, maybe I'm just not intelligent enough, but I have never found them that clear. And it seems that those applying the rules in different member states have also had trouble applying them, because there are a number of instances where, in fact, it doesn't seem to have worked very well. And so if you say you've got access to a court, that's great. But of course, you're going to get more people coming and knocking on the door. And you're going to get them saying, they applied the system wrong to me. Once you give them access to a court, then you do, of course, have people who are able to challenge. And this is where it links across to the application of the criteria in the cases that the colleague was implicitly mentioning, cases like AS and Jafari, cases like Mengistabe, where you're talking about the application of the criteria of crossing the frontier. Were the people crossing the frontier illegally in AS and Jafari, when the frontier doors, the gates at the crossing were wide open, and there were people, Croatian officials, in uniform with their hats saying, come along, madam, bring your little boy. Oh, he needs to go to the toilet. Bring your little boy. There's some toilets over there. There's buses down there ready to move you on. You know, it was all an organized frontier crossing. Was that an irregular frontier crossing? Well, you know, the court and I disagreed about that, and the court and I disagreed about Mengistabe. Actually, the irony is that probably in a very, very rough and approximate way, if we're looking at how many asylum seekers ended up in which member states, we may have ended up more or less with the same position, either under the Sharpston solution or under the court solution. But your basic issue there, your basic problem, was really a problem that actually the regulation was not really designed to deal with the situation that it was dealing with. And I asked the very open question about the rule of law. When you have a law, e.g. the Dublin 3 regulation, which wasn't designed for the situation that you're facing, actually, what is a court meant to do? How are you meant to deal with that? You know, if the surrounding circumstances are such that the rules don't actually permit you to deal with it, then what are you meant to do? But let's come back a little bit now to the Article 27 issue, because one of the things that may happen is that, of course, while an asylum application is being processed, actually circumstances may change. You know, it takes time to process an application. and the circumstances of the individual may change, and the circumstances may change in the country where they came from. I mean, everything may change. Are you going to say that you freeze everything in time at the moment when the asylum application is lodged, or are you going to be able to invoke later facts? This takes me on to the judgment in Shiri in case 201-16. That was the first case to involve consideration of later facts. The procedural history is immensely convoluted, and I'm not going to try to take you through it because it's a nightmare, all right? But the important element in the very convoluted procedural history is that he was challenging the transfer decision, which involved determining what were the consequences of the fact that the 6-month time limit applicable for transferring Mr. Shiri to Bulgaria had expired. Well, if you say that time limit had expired, you are thereby requiring the National Court to take account of a fact, namely that the transfer period has expired, the 6 months have expired, a fact that by definition occurred after the transfer decision was made. The transfer decision is made, the 6-month period runs, the 6-month period ends. New fact, transfer period, that 6-month period has expired. Mr. Shiri says to the National Court, you should have regard to that, and therefore you can't transfer me. Well, should you read Article 27 of the Dublin III regulation as allowing Mr. Shiri to raise that issue in those proceedings and to say to the court, look at that later fact? The whole case turns on it, but can he say that? Well, the court first established that where the transfer doesn't happen within the transfer period, automatically responsibility for considering the substantive asylum application transfers back to the requesting state. This is one of the many elements in the Dublin III regulation where if you don't do something within time, you get punished, if I can put it like that. You know, if you don't get the person transferred within the transfer period, you're then stuck with looking at their substantive application. And we had a lot of stuff already there about having the right to a proper remedy. But then the court goes on to look at whether you can invoke the legal consequence based on a later fact in proceedings covered by Article 27. And the court first tries not to have to deal with it because they say, look, in any event, the national authorities shouldn't be trying to transfer the person if the transfer period has expired. I mean, they shouldn't be doing that, right? They should, on their own initiative, they should take the necessary measures to acknowledge their responsibility. They should proceed without delay to examining the substantive application. All well and good, but what happens if they try and transfer you, yeah? They then went on to say, actually, you've got to interpret Article 27(1) as meaning that you have to have an effective and rapid remedy available to you as an applicant, which enables you to rely on the expiry of the 6 months period that occurred after the transfer decision was adopted. Now, fortunately, the national law in Shiri's case, the Shiri's case happened in Austria. In Austria, the national law did actually allow you to take account of a later circumstance. The question was therefore in Shiri whether Article 27 stopped you from relying on that element in the national law. Did the EU law overriding the national law stop you from relying on that in the national law? And the answer was, no, it's okay. You can rely on the national law meets the obligation to provide for an effective and rapid remedy because it allows you to look at this. And that takes me neatly straight on to case C19419 HA against État Belge, which is currently pending before the Grand Chamber, and in which my successor, Advocate General Rantos, duly presented his opinion on the 2nd of February. And that opinion is available, in the usual place on the Courier website. Now, this is a case which had been assigned to me in 2019 as the Advocate General. And you will gather from the way that I have been speaking that I care rather deeply about access to justice in the context of refugee rights. I make no apology for that statement. My family on my father's side came as refugees to the UK at the end of the 19th century. And so, you should always disclose why you have a position. I care a lot about refugee rights because I am the descendant of refugees. I wrote a shadow opinion in HA looking at the issue of access to a court under Article 27, where you have later facts. I need to tell you briefly the facts of HA so that you see why HA matters. Mr. HA is a Palestinian. He arrives in Belgium and he applies for asylum, and the Belgian authorities contact the Spanish authorities and ask them to take charge of Mr. HA because the Spanish authorities had given Mr. HA a visa, and that is one of the Dublin criteria under which a member state becomes responsible. And the Spanish authorities accepted that request. And so on the 1st of August 2017, the minister adopted a decision refusing Mr. HA leave to remain, and they ordered him to leave Belgium. That was the 1st of August 2017. And on the 22nd of August 2017, Mr. HA's brother arrived in Belgium. And my recollection of the file is that the narratives of both Mr. HA and the brother in terms of explaining why they should be given asylum are narratives with common points. So actually, if Mr. HA's brother had arrived before the decision was taken rejecting Mr. HA's leave to remain, you would naturally have applied the two together and looked at the two together. But Mr. HA's brother arrived 3 weeks after that decision was taken. So Mr. HA applies for annulment of the decision, and while that is going on, of course, they're beginning to look at the brother's asylum application. And Mr. HA, not surprisingly, says, look, there are similarities between my application and my brother's application. If you're going to look at this fairly, you need to look at the two applications together. Now, under Belgian national law is not the same as Austrian law, which applied to Mr. Sherry. Under Belgian national law, the Conseil du Contentieux des Étrangers said we are restricted to reviewing the legality of the administrative decision in Mr. HA's case. We can't review the substance, and in assessing legality, we cannot take account of events or circumstances such as the arrival of Mr. HA's brother in Belgium and the brother's application for asylum, which occurred after the administrative decision in Mr. HA's own case was adopted. So I'm going to pause there and say, imagine that Mr. Sherry's case had happened in Belgium, right? Mr. Sherry would not have had a national law on which he could rely. And it also shows you why Mr. Sheary's case and the decision by the court doesn't cover HA, because in Mr. Sheary's case, there was a national law. So the court could say in that case, oh, it's all right, just apply the national law. In HA, we don't have a national law on which to rely. So the court has to decide, in circumstances such as this, where there are later facts, to what extent must a court, looking at a challenge to a transfer decision, have regard to later facts if the applicant is going to have an effective remedy? It's a big question. It's a big question. That's why it's before the Grand Chamber. I am not going to prejudge or be stupid enough to try to guess what the Grand Chamber is going to do with it. They have Mr. Rantos's opinion, which is, I think, fair to say, more conservative than mine. They have my shadow opinion. Also, if they want to look at it, I am told informally, very informally, you can imagine the court is a place from which sometimes you hear things that reach you. I gather very informally that at least some people have looked at the shadow opinion, and that makes me very happy, because I did respectfully spend a lot of time on the shadow opinion in order to try to put the issue before the court in a way that illuminates it from a different perspective. It is an important issue. There are all the arguments that are always made by the member states, which you, in shorthand, you can describe as being the floodgate arguments. Oh, we can't let this happen because if we do, we'll never get rid of anyone. Everyone will challenge everything. All these activist left-wing lawyers, this is what's said in the UK very often by the current Home Secretary, Mrs. Patel, that, you know, they're all lefty lawyers and they all clog up the system by bringing cases. All right, well, I'm sorry, Mrs. Patel, sometimes the rule of law requires that people should act, and sometimes even act for free, on behalf of applicants in order to try to ensure that the rule of law is what is applied. We will see what the court does with case C-194-19. But it now has, and if you're curious, go and have a look at the two opinions and decide for yourselves what you think you would do, and then we'll all watch and see what the court does. I'm going to ask now if there are questions arising out of the first part of this session.
Thank you. Are there any? I don't see.
Je crois que c'est la pause café alors.
Peut-être.
On va faire une petite pause café. Moi, je vais sortir me chercher un café, de préférence sans marcher sur l'un de mes chiens qui vient de me rejoindre, n'est-ce pas? Mais qui est très sage et qui est couché là. Et je vous suggère de reprendre juste avant 10h10 alors, comme ça, voilà. Parfait. À tout à l'heure. Alors.
Eleanor, I don't know if you see that there is a question on the chat box.
I don't know how to go to the chat box. You better tell me.
Okay. Should I read it?
Please. Comme vous voulez, ou expliquez-moi comment arriver sur le chat box. Je n'ai aucune dans Teams, je n'ai aucune idée. Je sais pour Zoom ce qu'il faut faire, mais pas pour Teams.
C'est au-dessus.
Oui.
Et donc il y a une icône avec des petits bonhommes et juste à côté une icône comme justement une bulle avec des paroles dedans et il faut cliquer dessus.
Aha.
Vous voyez?
Attendez.
Avant le petit bonhomme avec sa main.
Oh, oui, j'y suis. What do I think about that?
Et il y a tous les noms des gens et puis il faut aller en bas.
Oui, 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 non, mais je suis en train d'essayer de comprendre mais je vois aussi ce qui me rend très méfiante. Florian Hassel-Gast. Il est d'où, Florian Hassel?
Ah ben ça justement, je ne le sais pas, il faut peut-être lui demander, il est peut-être là, probablement.
Non, parce que je me méfie toujours par des questions comme ça qui sont super précises et normalement cela vient de quelqu'un qui est mêlé dans une affaire ou qui est en train de gérer quelque chose de la part pour le compte d'une administration et qui veut avoir l'avis de l'avocat général qui peut citer par la suite.
Mais donc il faut poser la question, je pense.
Je crois également.
Parce qu'il y a plusieurs invités qui sont aussi des collègues d'autres universités. Donc
Oui.
ça peut...
Et il y avait pour l'inaugural, il y avait pas mal aussi des gens qui étaient du service juridique de la commission.
Ah oui.
Et du conseil, j'ai vu ça. Grâce à la fiche très, très utile que vous m'avez transmise. Hein? Non, mais c'est aussi pourquoi je vous ai demandé. Parce que comme ça, on sait effectivement, on a une idée, n'est-ce pas? Et là, j'avais constaté.
Ouais.
Et il est qui?
Human Rights Consultant, I've seen it. Ludwig Boltzmann Institute of Fundamental and Human Rights.
OK. Ben, probablement, la réponse consiste à poser une question à la cour. Hein? Ouais, OK. Très utile. Merci à la personne qui l'a trouvé sur Twitter. C'est un réflexe que j'ai moi, mais pas très vite. Hein? Donc, merci beaucoup à la personne qui a eu le bon réflexe, mais qui est plus adepte que moi.
Et donc, Eleanor, les personnes sont reconnectées, donc c'est quand vous voulez pour la suite.
OK, très bien. OK. Alors, let us move on from that first part in terms of what degree of access do you get under Article 27. Let us move on to the question of contesting solidarity. And I am going to be in two languages for this part because I want to, when I'm talking about the challenge to the relocation decisions, I suspect I'm going to be in French. Basic facts that you need to have. There was indeed a refugee crisis, a big refugee crisis in 2015. And it became very obvious that the Dublin system, if you just applied it, that this basically wouldn't work. So the council adopted two decisions which introduced provisional measures for the benefit of what they called the frontline member states. Council Decision EU 2015-1523 and Council Decision EU 2015-1601. Those decisions were about a week apart in terms of their timing. The decisions put in place detailed arrangements to relocate applicants for international protection. Those applicants would otherwise automatically have fallen to be dealt with in Italy or Greece, and the point of the decisions was to share them out among the other member states to alleviate the burden on Italy and Greece. We are talking a lot of people. The first decision was in respect of 40,000 people. The second decision was in respect of 120,000 people. 40,000 in the first decision, 120,000 in the second decision. So you can probably imagine that if you're going to have measures that deal with that number of people, that tells you already that we are in an extraordinarily exceptional situation. I'm trying to convey to you, and I'm not sure I'm doing so adequately, for the member states to do anything that alters the Dublin system is strange. And for them to do something that alters the Dublin system by that amount is truly extraordinary. This was not something which was entirely appreciated by everyone. And the Slovak Republic and Hungary duly brought a challenge against the second of those decisions, decision 2015-1601. Now, this was absolutely their right, okay? You don't like the decision, you challenge it. It was an extraordinarily elaborate challenge. My late and much regretted colleague, Advocate General Bott, was the Advocate General in that case. And he was scrupulous in his coverage of the various arguments that were raised. When I say scrupulous, I really, really mean scrupulous. His opinion, which I have sitting in front of me because I'm contributing to a Liber Amicorum in his memory, his opinion runs to 343 points. All right, it is a monumental opinion, and it really, you know, it goes over everything. It examines it very, very scrupulously, the whole range of arguments that are advanced, and at the end of the day, he says effectively, nice try. But actually, no, you don't get home with that. Then, of course, the court has to deliberate it. And so they begin with the Advocate General's opinion, expect them to do that. But they also conduct a very full analysis of their own. And for that, they produce a judgment, which is, again, a very, very extensive judgment. It's a judgment, it's not very often that the court actually bothers to give you a table of contents at the start, but it does for this case, which I'm failing to bring up, of course, naturally on the screen, because that's what happens. This is why I never normally accept to teach with computers, because they are insanely tedious. The first page of the Grand Chamber's judgment, je passe en français parce que je l'ai en français là. Donc on a la décision à attaquer, contexte, genèse et contenu, la procédure sur les recours, et puis on passe aperçu des moyens, observation liminaire, et puis les moyens, on passe en revue les moyens. Et c'est vraiment à la peine fine. Donc, les moyens tirés de l'inadéquation de l'article 78, paragraphe 3, TFUE, en tant que base juridique de la décision attaquée. And there they put together the different branches that will come up. Ensuite, sur les moyens relatifs à la régularité de la procédure d'adoption de la décision attaquée et tirée de la violation des formes substantielles. And again, there's an assembly here of all the different elements And it really was every argument you could ever think of was put in by Slovakia and Hungary. Everything about whether you'd had the national parliaments agreeing, or about the languages regime, about whether it's been done unanimously. It was literally every argument that good lawyers can think up to challenge the validity of the decision. And then there were substantive challenges to the actual content of the decision after the procedural challenges, because there was also the argument was raised that if your objective was to deal with the problem, then this wasn't an appropriate way, the inaptitude de la décision attaquée à atteindre l'objectif qu'elle poursuit. And then une objection tirée du caractère non nécessaire de la décision attaquée au regard de l'objectif qu'elle vise à atteindre, et violation du principe de la proportionnalité en raison des effets particuliers de la décision attaquée sur la Hongrie, et puis violation des principes de sécurité juridique et de la clarté normative, ainsi que de la Convention de Genève. You will understand from this that it was an enormous, thorough, careful analysis. And the court, at the end of 347 paragraphs, so that's more or less a dead heat between the Advocate General and the court in terms of how many. Yeah, the court wins by 3 paragraphs in terms of the amount of coverage necessary to deal with that application. They decide there is no actual substance to this. Les recours sont rejetés. Hello, can you hear me again? I had a slight glitch there, but I hope I'm back.
Yes.
So you would have thought, so far, so good. The rule of law is being respected. There has been a challenge. The challenge has been looked at by the court. It has been looked at in great detail in the grand by the court and by the Advocate General. And the answer is that there is nothing wrong legally as a matter of EU law with these decisions. Therefore, the decision is binding, because if you've looked at it and the court has told you that there's nothing wrong with it, you would think you derived from that the conclusion that, all right, you apply it. Well, that's not what actually happened. Despite the fact that the decision had, so to speak, been validated by the court, the relocation mechanism didn't actually work the way it was meant to work. Instead, 3 of the 4, I mean, let's be fair about this. Nobody, I think, really applied everything in the relocation decision quite the way that ideally, in an ideal world, it would have been applied. But it was particularly noticeable that the 3 Visegrad member states, 3 of the 4, Poland, Hungary and the Czech Republic, refused to implement the decisions. When I say they refused to implement the decisions, it would be more accurate to say that the implementation was virtually non-existent. I mean, if you implement a decision by having 30 people, 50 people that you admit, that's, given the scale of the problem, that's not really complying with the decision. So, infringement proceedings were brought against those 3 member states. There is, of course, then the question, what does the court want to do with this? I mean, Do you send this to the Grand Chamber, or do you deliberately not send it to the Grand Chamber? Well, the decision in these 3 infringement cases is a decision taken by a chamber of 5 judges. It just so happens it's a chamber of 5 judges which had the president sitting in it. He was filling in for an absent judge. So it is a chamber of 5 judges, but it's an interesting chamber of 5 judges. And one might say it's a rather strong chamber of 5 judges. The argument that was being run by the 3 defendant member states was not, so to speak, that the decision in the earlier challenge had never happened. I mean, you know, of course it had happened, right? But the argument that was being run, as well as lots and lots and lots of admissibility and procedural arguments, which are covered in both the opinion and the judgment, the essential argument that was being run was to say, we have a get out of jail free card. We know that this decision exists, all right? You know, the decision exists, and the judgment of the court validating the decision also exists. And that's all fine and it's all lovely, but actually it's, so to speak, completely irrelevant. And you say, why would it be irrelevant? Sorry, I didn't quite get that. Why would it be irrelevant? To which the answer is, but you see, if you take your copy of the treaty off the shelf, as I have just done, and if you turn there to Article 78, you will find that we have common measures, and that's all absolutely fine. It's all beautiful. There's no problem about having common measures, but you will find also that member states are, this is all this, I should pause to say, this is part of the treaty chapter which deals with policies on border checks, asylum and immigration. So it tells you that the union is meant to develop a policy, and that's all good, and it's meant to develop a policy on asylum, and that's all terribly good as well. But there are a number of kind of reservations. It's one of the passages in the treaty where you can see the tension between doing things at EU level to put everything together, and on the other hand, the need to preserve the rights of the member states still to look after and deal with matters that affect their own security. And so what is happening is simply that we say, all right, we've got all of this stuff in 70 in that part of the treaty, but is that, what about a different provision? What about Article 72? So then you think, all right, why isn't Article 72 part of that story? Because that story is the policies on asylum and so on. But Article 72, a little earlier on, explains to you that the entire title on the area of freedom, security and justice, Title 5, the entire title shall not affect the exercise of the responsibilities incumbent upon member states with regard to the maintenance of law and order and the safeguarding of internal security. So you have a situation where the decision is taken under Article 78. And in Article 78 terms, apparently it's fine. It's been looked at by the court and it's fine. But the Visegrad states then play their joker and they say, don't worry about that. Under the general provisions on the area of freedom, security and justice, there is a general provision, Article 72, and Article 72 says this whole title shall not affect the exercise of the responsibilities incumbent upon member states with regard to the maintenance of law and order and the safeguarding of internal security. So shut the book, cross your arms, there we are. All we're doing in refusing to accommodate those decisions, in refusing to implement the decisions, is we are exercising our reserved power under Article 72. We take the view as member states that it would be very prejudicial to national security to have hordes of people coming in. We don't know where they've been. We don't know anything about their background. Having all these people coming in as applicants for asylum. We're not prepared to do that. I'm going to stop there and say, what do you think of that argument? Let's have some views.
Thank you, Eleanor. Does anyone wants to intervene? Yes, Angelo, Marleta.
Good morning. I was thinking with regard to the interpretation of internal security. Which kind of interpretation should we accept? Because otherwise it becomes and remains a unilaterally defined concept. Potentially member states have, in certain matters such as also criminal law and judicial cooperation, are jolly to stretch and to not comply with the EU law at this point. So that concept can be used or should be an autonomous concept defined by the court under EU law.
So sorry, your question is internal security going to be defined autonomously or defined as a matter of EU law?
Yes.
Mm-hmm. I mean, a similar question, of course, arises, you'll remember, in relation to free movement of workers, the derogation on grounds of public policy. You'll remember an older case called Bouchereau, where the court said that if you're going to say that somebody is going to be deported on public policy grounds, that it has to be their individual conduct, and it has to be a sufficiently serious threat. Right? You maybe remember that authority.
Yeah.
So we have other places in EU law where the court has already said it needs to be something individual rather than something global in relation to individual human beings. But I mean, perhaps you can also run the argument, yes, but if you have enough individual human beings, you get a collective effect. That's certainly an argument that got put forward. Thank you for that intervention. Other people, please.
Other people? Yes, Juliette Kasmaker. Juliette, you have to put your mic on. We can't hear you. Juliette?
Anyone else?
Yes, I don't see anyone else raising his or her hand, but through the chat box.
It's not working.
Can you hear me now?
Yes.
Oh, sorry. Okay. I just wanted to add that the risk with the Article 72 is that you can invoke internal security for any matter really of EU law, anything you don't agree with. So that's the risk. So I don't really know how the article works in practice, but I guess there is some sort of a proportionality test to respect in order to invoke it.
You're in very good company, because none of us know how the article works. You're in excellent company, because none of us, before this case happened, none of us really knew how Article 72 worked, right? So So don't worry about not knowing how it works. That's the usual position to be in with a new provision of EU law that you haven't looked at before.
Okay.
No problem at all, right? But I mean, you correctly identify a potential real problem. If you read that very broadly, it becomes a reason it can undermine more or less anything in Title V. I mean, it only applies to Title V, right? I say cheerfully, it only applies to Title V, right? But I mean, Title V is the entire area of freedom, security, and justice. So when you said it only applies to Title V, you are covering an awful lot of things when you say that. Yes, I mean, you are obviously you're dealing with the asylum arrangements, but you're also you're covering immigration generally. If we take Title V and we go through, we've got the policies on border checks, asylum and immigration, and that's what we've been concentrating on at the moment. But we also have judicial cooperation in civil matters, judicial cooperation in criminal matters, and then we have the police cooperation, right? And all of that is Title V. So if you can construe Article 72 as giving you a general get-out clause from everything in Title V, if you can show that you're worried about it being a threat to internal security, you've got a pretty maintenance of law and order and the safeguarding of internal security. You know, if you can use it in this way, you have a very big get-out clause from the entire policy area of the area of freedom, security and justice. I mean, that would be, as you say in English understatement, that would be non-trivial, right? Meaning that would be enormous. It would be very, very, very big. Okay. I'm going at this stage to tell you more than you knew before, but you will find it set out in fuller detail. I'm going to summarize. And if you're interested in it, please go and look at my opinion in the Visegrad cases, all right? The beginning of the answer to this is that if you look at the detail of the various instruments that together compose the area of freedom, security, and justice, you will find that within that area, there is a lot, within those detailed instruments, there is already plenty of scope for a member state in respect of an individual applicant whom they think will be a threat to the maintenance of law and order and public security, for a member state to take in respect of that individual applicant the necessary measures to ensure that there isn't a problem. There is a big section in the opinion which goes, perhaps rather painfully, through all the various EU directives, the procedures directive, the substantive directive, it goes through all the detail and says, look, if with this particular applicant you think there may be a problem, Article so-and-so allows you to do this. Article so-and-so allows you to curtail the time they can spend on the territory. Article 7, Article so-and-so allows you to do. In other words, look at the other elements of EU law that govern this situation. You will find within those elements, you will find that member states specifically have scope in respect of an individual applicant to deal with a perceived problem, to investigate, if necessary, to exclude. And here's the, again, individual rights rule of law issue. Here is the point. Given that the legislation, the EU legislation, has within it those safeguards for member states, member states do not have, I'm going to say, a viable problem, a legitimate problem in respect of a particular individual who has applied for asylum, who turns out to be a bad character, because they can deal with him. And what is not permissible, but what was sort of behind the argument, is to say, well, I don't want foreigners in general. I mean, I don't want all of them because, okay, either I don't want them in general because I don't really want them, or it's all going to be terribly burdensome and I don't want to take the trouble. Well, yes, but look at the problem for the frontline states. Look at that issue. Look at the difficulties that that causes for those who are in the front line. And actually, we within the European Union, we have all of us to deal with this. To come back to the question that was put to me about the concepts of public order and security, I really, certainly in my opinion, I was just drawing on what was already there in other areas of EU law, on the basis that why go and invent the wheel if you don't need to? I mean, we know a bit about those elements, and we should build on that. I'm abbreviating because just as with the challenge to the validity of the second decision, there were a lot of additional arguments. There were, in this case, also a lot of additional arguments that were thrown in there in order, in the hope that something would work, something would stick. I do want to draw your attention, if I may be permitted to do so, to the end of the opinion, simply because there I did suggest that apart from the specific issues that I had dealt with, which mainly the scope of Article 72, that these proceedings did raise very fundamental questions about the parameters of the EU legal order and the duties incumbent on the member states. And it seemed to me that there were really three things very, very clearly that came through. The rule of law, which we're talking about at the moment, and also the duty of sincere cooperation and the principle of solidarity. I flagged up there the subcomponents of rule of law. I suggested that some of that involved compliance at a deeper level. It involves compliance with one's legal obligations. Disregarding those obligations because in a particular instance they are unwelcome or unpopular is, I suggested, a dangerous first step towards the breakdown of the orderly and structured society governed by the rule of law, which as citizens we enjoy for its comfort and safety. And I did suggest that the bad example is extremely bad, and it's particularly pernicious if the example gets set by a member state. I'm not obviously going to tie that to what I was saying as recently as yesterday evening in relation to the UK's current unilateral extension of the grace periods for the Northern Ireland Protocol. When a state disregards the rule of law, this is not a good example. It's not a good example at any level. At interstate level, it's not a good example, but it's also not a good example for democratic society as a whole. Because if the government and the state think that it's okay to disregard a law because they don't like it very much, then there is a very understandable reaction on the part of le citoyen lambda, Joe Citizen, which is along the lines of, well, if the government says that the law doesn't matter, why should I be so scrupulous about the law? I've just been told that the law doesn't matter when it gets in the way. This is not a good example to be setting. I did go on in that opinion to stress the importance of the duty of sincere cooperation. It is there for a reason. It's there in the early part of the treaty, and it's there because it does actually matter for the purposes of making the EU work, that actually the member states do have to try to work together to attain the objectives in the treaty, and they are meant to refrain from action that jeopardizes it. Under solidarity, well, am I going to quote to you? Yes, I think I am. I went through a number of cases involving solidarity, and I permitted myself at the end of that to recall an old story. It's an old story from the Jewish tradition, but one that perhaps deserves wider circulation. So I thought I would give it wider circulation in that opinion. It's a simple story. You have a group of men who are traveling together in a boat, and suddenly one of them takes out an auger. That's the tool you use to make holes with, right? He takes out an auger and he starts drilling a hole in the hull of the boat underneath himself. So they're here, they're in a boat, they're on the water, and here is this man with an auger making a hole in the hull of the boat. And his companions look at him and they start remonstrating. I think, why are you doing that? And he says to them, what is it to you? Am I not making the hole underneath my own seat? Yes, they say, the hole is underneath your seat, but the water will come in and will drown all of us. That is perhaps not a very conventional explanation for what solidarity means, but I hope that it's one that may stick with you as an explanation. Because these cases really demonstrated an absence of respect for the rule of law and an absence of respect for sincere cooperation, and really an absence of respect for solidarity. And I think those points matter. Now, I've deliberately left a little space at the end because I'm conscious of the fact that there was a question that came up in the chat which relates to the first part, which I haven't answered. And there may also be some other points that people would like to bring into the discussion. The question that came up in the chat was from Florian Hassel. And he said, thank you for this interesting lecture. What do you think about the fact that the Dublin regulation does not expressly allow applicants residing in Greece to challenge the rejection of a take charge request in front of an independent court? E.g., a take charge request by the Greek Asylum Service, presumably to another service, in order to reunite with family members in Austria or Germany. I want to, in Germany, applicants can challenge, so I'm just trying to get down this. In Austria, in Germany, applicants can challenge the rejection in front of administrative courts. In Austria, the highest administrative court refuses such an individual legal right. May I perhaps begin by asking Florian to expand a bit on his question? Can I give you the floor, and can I ask you to expand on that? I mean, when you say the rejection of a take charge request, the take charge request would be sent by Greece to another member state. Or, I'm sorry, I'm not, my problem is I'm not actually sure I've understood the parameters within which you ask your question. So forgive me, and could you please clarify a bit?
Florian, do you hear us? I see that he's connected, but no mic. There seems to have no reaction. I'm sorry. Florian Asser, do you hear us?
Can you maybe if I type a message,
I could do that.
Please.
No, I don't see any reaction.
I mean, I'm going to say that there is a kind of general question. We'll only know what the limits are of the Article 27 route under the regulation by people testing it, right? I mean, that's a fairly simple and non-controversial statement. But in order to test it, you need a national court to be prepared to ask. Oh. All right, I've just seen what's been put in the chat, and I think I need to respond to it. I wasn't calling him out. I was trying to understand where the question came from. Because as the speaker, you have a right not to be waylaid by a question where you're being asked for legal advice. I am giving a lecture, which is a student lecture. Guests are very welcome. However, there are rules of kind of fair play, all right? If there is a reason behind asking a question, the proper way of dealing with that is to declare at the beginning who you are and why you are asking the question, because then we all know what is happening. And it is one of the real difficulties about being a lecturer doing things by Zoom is that you have no idea whether you're going to be ambushed. If you are in a lecture hall, you can see the person standing up and asking you the question, and you can also, in the way that they speak, you usually find out a bit more about them. But I am actually very serious. I am perfectly prepared, as you have gathered, to engage with the question. But I am not prepared to be ambushed. And I am not prepared to be ambushed because it is actually not fair on the speaker. It puts the speaker in a very invidious position. And if I have to guard against being ambushed, then I have to be much less free in what I am saying. I have to teach in a very different way, and I will be much more boring, all right? So far, I have been paying you all the courtesy of assuming that I can speak freely, and I have been speaking very freely. Now, if I am going to be asked a question which is a loaded question, I'm not saying that necessarily was. I don't know, which is why I need more information. But if I'm going to be asked a loaded question, then I have to be more defensive in how I engage. And I have to say very pompous things like, well, speaking as a former member of the court, I do not think that it would be appropriate for me to answer that question, right? Now, I mean, I can do that, but it won't be very interesting. It's more interesting if we say this is an academic environment and we are people searching after understanding and greater knowledge, and we can ask each other questions. But then I do need to know where the questions are coming from.
Thank you very much, Eleanor. I don't see any reaction, so I'm afraid that Florian Hassel is not going to.
I'm happy to engage.
If I know.
Florian is still there, and if he would like to tell me more information about the problem, I am happy to engage with looking at the problem. But that is not the same thing as, you know, can you give me the answer to this question because it's something I'm dealing with? By the way, you know, it does happen at conferences, at public lectures, that people ask you questions which are questions, you know, where really they'd like the answer to the problem that they're looking at. And on the one hand, I see they'd like to know the answer to the problem, but actually that's not really within the parameters of what the exercise is about. But I'm happy to discuss the issue if I had more understanding of what it's about.
I see that another guest, who is Loxa Alesini, who already intervened, is willing to say something. So Loxa, you have the floor. And you may introduce yourself, maybe.
Yes,
thank
you.
Yes.
As a guest, I'm actually a PhD researcher at Lund University in EU migration law. I actually have a question I want to ask, I mean, the importance of access to court and full review for asylum seekers in the context of rule of law is something you've pointed out through greatly, both in today's lecture and in the inaugural lecture. I was wondering to what extent do you see the proposals put forward at the new pact and kind of limiting judicial review for asylum seekers, both in relation to Dublin, but also in relation to procedures, the procedures directive. To what extent do you see there an interplay with rule of law? And to make myself more clear, my question would be, is there a rule of law issue only in relation to the design of the system and how, like, member states responded during the refugee crisis, or are there broader rule of law issues in the way the EU legislation is taking a path forward after the refugee crisis? And this is, of course, like a question primarily of your opinion and not a question of what courts would answer to that, because I understand there's a long way until we have more case law on that.
Well, I will respectfully say that you are way ahead of me, because I don't know the detail of the proposals. You are researching in this area, and I honor you for it, but I don't actually know the detail of the proposals. I am not in a sense surprised that there should be such proposals, because there is always a tension between the administration that wants to be able to get on efficiently with processing things and doesn't want to be challenged, right? And the individual person whose case may in fact not be handled correctly. When I say their case may not be handled correctly, I don't mean necessarily that there is ill will or malice or say, I mean, mistakes can be made. People can be in a hurry, there is pressure of work, there is a general policy guideline that if in doubt, say no. I speak as somebody who, when I was a barrister, did a lot of cases actually acting for the Home Office in the UK. The Home Office being the body that decides on immigration cases in the UK context. And so I saw and I argued a lot of cases from the side of the government. All right, those were my instructions. And I got up in court and I did my job, right? And it was very clear from those that there was great pressure on individual case handlers to get through their cases quickly, right? Because there were lots of cases. And also not to say yes to all these requests, even if they might have sympathy for the person, because actually the basic idea was to say no. And there is a rule of law issue in as much as, and this ties through to what I was saying yesterday about in the context of competition law, if there is going to be confidence that a system is robust and fair, sometimes the administration has to lose in its own courts. If the administration never loses, then we know that the system is fixed. And if you can never get to the court to test whether the administration is right or wrong, then we will suspect that the administration has things that it wants to hide. So there is, as well as justice for the individual person, there is actually a broader issue about sort of structural stability and legitimacy, that it should be possible to get through the door of a court and test whether what is being done is in fact lawful. Now, you will hear in any of these cases, you will hear the argument, which is called by the label the floodgates argument. If we open the door and we open it too wide, then we get all sorts of cases that come through and the whole thing clogs up, right? Yes, you need to be vigilant in how you patrol that. Within my own tradition, actually the independent bar, and it is very independent, the independent bar itself plays a part in patrolling, because if somebody comes along to a barrister for legal advice and the case is plainly rubbish, the barrister will tell them that. And the barrister will say to them, I do not advise you to take this. I advise that it is hopeless. I advise that you are going to waste everyone's time and money. And what's more, if I will put that down in writing. I will say, no, absolutely, this is a useless case. And you may not like what's happening, but I advise you that you have no argument in law. If you do get in front of the court and the case is ridiculous, the judge will then kill you. I mean, the judge will not, but the judge will make sure that you don't do that, make that mistake twice. Because the judge is also somebody who comes out of the same tradition, who is a very experienced practitioner who spent the first 30 years of his life giving people advice, take this case, don't take this case, right? And he is not going to be sympathetic to a complete rubbish argument. Ms. Sharpston, is that really your best point? Well, Ms. Sharpston, the law is plainly against you on this, and you've cited to me the authorities, so you must be aware of them as much as I am. What are you doing here? And it's not a very good argument to say, well, my client wanted me to come. I will report you to the Bar Council. So there are other filters in the system. And it is a favourite argument by the administration, the floodgates argument. I'm going to give you an illustration from a completely different context. The very last case I did as a barrister, and a case that I did pro bono, I did for free, was a case about trying to get protection for the wreck of a merchant ship that had been torpedoed in the Channel, a vessel called the SS Storer, trying to get the wreck protected as a war grave because 21 people had died when that ship went down. I was acting for the daughters of one of the men who was drowned. And the Ministry of Defence had taken the approach that a merchant vessel, this was a merchant ship, an armed merchantman carrying war supplies, that a merchant ship did not fit within the rules. It wasn't part of a navy, it didn't count, right? And we challenged that. And the Ministry of Defence tried to say to the court, floodgates, floodgates. If we allow this through, there'll be thousands of applications. You know, it will be terrible. We won't be able to deal with it. And I stood up and I said, look, it took the archaeologists and the historical researchers 5 years to verify that this is indeed the Storer, the wreck of the Storer, to put together the narrative about what was on board the Storer, to find out where she was going, what she was doing, and therefore to be able to mount the argument that this vessel was being used for war purposes. This hunk of rotting steel in the channel, this was in fact being used for war purposes, and that she should be designated as a war grave, not least in order to honour the men of the Merchant Navy who died in the Second World War. And there is no designated vessel to honour them, and yet they had heavier losses than any of the armed forces. And that is why this is here. But please, the floodgates argument is completely ridiculous, because there is no way that that amount of time and effort can be put in order to run the argument in relation to thousands and thousands of wrecks. You can be quite safe, my lord, in rejecting the floodgates argument. And I mean, I tell you that story because the floodgates argument is always run. Whether it makes sense or it doesn't, it will be run.
Thank you, Eleanor. There is Angelo Marletta who raises his hand. So, Angelo, you have...
Yes. Good morning. I present myself. I'm a postdoctoral researcher at the Centre de Droit Européen at ULB. And I wanted to ask you a question referring to your opinion on the relocation cases and your paragraphs on solidarity. You laid down very thought-provoking and intellectually stimulating paragraph there. And I wanted to ask you, would you see a role for the principle of European solidarity in a different situation where we are not just talking about solidarity between member states, but between individuals, in an horizontal dimension between individuals? I'm thinking in this case quite clearly at the pending case against Hungary for the criminalization of organization or individuals providing advice, legal advice or assistance to asylum seekers. And I would like to know if you've considered that this could be actually a dimension of the principle of European solidarity, or if we are talking on something that is completely different.
I love your question, sir. I really do. The treaty itself speaks of solidarity between member states. I think that there is, but I am talking here really kind of blue sky. I am talking about what I hope may develop over the next 10, 20 years. I think that if we talk about people being citizens of the Union, I think that the concept of citizenship includes duties as well as rights. The case law on citizenship has mainly been about rights because people have been seeing whether citizenship enables them to claim something that they can't get by a different route. So I know why the case law is like that, okay? But I am going back to older ideas of what it means to be a citizen. In one sense, I'm going back as far as ancient Greece, where if you are a citizen, you have an obligation of solidarity to defend your city, your polis. And if there is an attack on the polis, you know, actually you need to get in and help people. And you probably need to get your armor and go and fight. And I think that there is, if you start to look in the social if you look in the social areas of legislating, there are some clues there that European solidarity may not just be about solidarity between member states, but also solidarity between peoples. And when you speak of solidarity between peoples, then the next stage along that road is to say that individual people, i.e. citizens, also have some degree of solidarity that they should be showing. I mean, we have this in a national context, after all, because we pay taxes that fund unemployment benefit or that fund universal health care. And we accept to do that because we accept as members of a society that we have a duty to support other people. You know, the introduction of the NHS, the Beveridge Plan, the introduction of the NHS in the UK was a very striking illustration of that principle. Actually, we need to have a national health service that is free at the point of use. That was the philosophy behind it. And the National Health Service is a very sacred national treasure in the UK. It may not be properly paid for, but it certainly is a national treasure. You know, I mean, you couldn't conceivably say the National Health Service is something we should get rid of. You know, I mean, there would be an outcry. So to some extent, solidarity, you know, I think this really touches to a bigger difficulty, which I mentioned in passing when I was doing the Hamlin lectures in the UK in the autumn, that the European project as such has brought a lot of benefits, and the benefits have been banked kind of invisibly. People have not really engaged as citizens with the idea of being citizens of the Union and with what that may require of them in terms of active commitment. Now, that doesn't fully answer your question, but it is maybe I mean, your question is a lovely question. It may help to enrich your thinking on that.
Thank you very much.
You're very welcome.
I think I'm looking at hands raised, and there is Janja Semantic. Yes, you may ask your question or may your comment.
Yes, hello. So I wanted just to use this opportunity to present myself because I didn't do that in the first place when I asked the questions. I am a PhD researcher at the university, and I deal with the issue of the role of the Court of Justice in the asylum system of the EU and what was its contribution. And I believe it is a huge contribution. And I think that your lecture was in a way confirming that to me. Also, I would like to thank you for being that open. You said it is not always easy because you're not sure who is on the other side, but it was very useful for me to hear your train of thought, let's say, and your legal reasoning in order to understand how the court and the Advocate General of the court comes down to their conclusions. So my question, or maybe just a general comment that I got from your lecture today, from me and from my research, the conclusion would be that, or the question for you, do you agree that the quality of the legal reasoning also affects the rule of law? Meaning that since we have a lot of judgments, and I believe there will be even more in this issue of asylum, and not all of them, let's say, are engaging, and also the opinions of advocates generals are very much important, having in mind the structure of the judgment versus the opinion, which is completely normal. I mean, that is their character. So I just wanted to ask whether you find that the quality of legal reasoning in terms of using the legal methods and maybe being more open about the legal methods that are being used in this legal reasoning can contribute to the rule of law in the field of asylum. Thank you.
Thank you very much. First of all, thank you for your very kind words. Because I prefer to be open, and I was a little disconcerted by Mr. Florian Hassan's question, which is why I wanted to find out more about where he was coming from. I agree with you completely that the legal reasoning is very important to the rule of law, and indeed I think it's vital to the rule of law. We have a requirement in most of our systems that a court should reason its answer. We don't think it's okay if the court just, stands up and says, you lose. Yeah, we do not consider that that is an adequate discharge by the court of its judicial functions. And I really agree with an old comment that was made. If you ask the question, who is the most important person in the courtroom? The answer to that question is the party that's going to lose. The party that's going to lose has to understand why they lost. They may not be happy that they lost. They probably aren't. But they need to understand, as a matter of connected legal reasoning, they need to understand why they lost. And if the legal reasoning doesn't pass that test, the winner's going to be happy, right? The winner couldn't care less. The winner's going to say, yeah, I won, Maybe there's a problem about the reasoning of paragraphs 43 through to 47. I don't care. I won, right? But the loser is going to care. And the loser is going to say, the court didn't understand this case. Look at the mess look at paragraphs 43 to 47. Just look at them. They don't stack up. They aren't consequent. They aren't logical. This is rubbish. This is palm tree justice. Yeah, all these phrases. So the reasoning is really important. And that takes you across to the question of the workload, the pressure to get through things quickly, the concern with the statistics, the interesting question as to how you best use your advocate general, how many cases should you have opinions in? By the way, there is no perfect answer. There are cases I can think of that got an opinion for maybe the wrong reasons, and other cases which didn't get an opinion where maybe they should have got an opinion. And indeed, I'm not going to identify them, but I can think of one or two cases where the court decided in relation to one of my cases that an opinion wasn't needed. And a couple of months later, I met the reporting judge in the corridor, sort of like this, tearing his hair out. And I said, you don't look very happy this morning. And he said, oh, God, he said, you remember such and such a case. It's in deliberate and they're going round and round in circles. I should have asked you for an opinion. Right? To which the answer was, it's a bit late now. Actually, it's not totally late. It is possible. It happens very rarely. But it is possible for the court, in a case which has started to process without an opinion, to decide that it needs an opinion, maybe a bigger formation of court, and to come back to the general meeting and ask for the case to be reallocated. And I have known it done. But it is done very, very, very rarely because, of course, it involves you being big enough to admit you made a mistake, and that's not so easy. And also, it's very bad for the statistics because that case will naturally take much longer to decide than if you somehow get on with it. So, good legal reasoning also comes at a price. But having given you those very elaborate examples, I agree totally with the proposition that the quality of the legal reasoning is extremely important to the rule of law. Thank you.
Thank you so much, Eleanor, for all about the presentation and afterwards the Q&A session. I think it was very rich. So we're a bit over time, but I was watching the clock. And so I think we raised the end of this session. The next session of the Francqui Chair is going to happen on next Monday, the 15th of March at 4 on Teams. And I am personally looking forward to hearing the following development on terrorist suspects and the rule of law. So thank you very much.
Thank you.
And have a good afternoon.